There are men who carry their whole lives in a single folder, not because they have so little, but because they have learned, through long and sometimes painful instruction, that what matters fits, and that what does not fit does not matter. Ezra Mensa was such a man, and on a cold Tuesday morning in November, he carried his entire argument against a corporation worth $40 million in a manila folder under his arm, and he walked through the front doors of the courthouse on Meridian Street as if he had every right to be there, which he did, though no one in that building would have known it by looking at him. The courthouse on Meridian Street had stood for 81 years, and in that time it had absorbed every kind of human story: divorce, inheritance, fraud, murder, the small, quiet devastations of civil dispute. Its marble floors had been walked by the guilty and the innocent, and the many people who were neither and both at once. The building had a smell, stone and wood polish, and something older, something institutional, the smell of authority that has been exercised so many times in one place that it has become part of the air itself. On this particular Tuesday morning in November, the sky outside its tall windows was the color of old bone, and the light that came through was thin and gray and fell across the wooden benches of Courtroom 7 like the light in an old photograph, precise, a little unforgiving, recording everything without judgment. Ezra Mensa had been sitting in the back row of Courtroom 7 for 2 hours before his case was called. He sat very still, the way a man sits still when stillness is a discipline and not a default. He was 67 years old, slightly built, with close-cropped white hair and a face that had been shaped by decades of weather and thought into something that was not handsome in any conventional sense, but was deeply, unmistakably present. The face of a man who was always, entirely, where he was. He wore a suit that was clean and pressed but old, the lapels a half-inch too wide by the fashion of the current decade, the color a dark navy that had faded at the elbows to something closer to blue-gray. His tie was a deep burgundy, knotted carefully. His shoes were polished. He had polished them himself that morning, sitting at the small table in his apartment, working the cloth in slow circles, the same way his father had done it, and his father's father before that. Not because anyone would look at his shoes, but because the act of doing a thing properly was its own argument for the value of the thing. He held in his hands a folder. It was a plain manila folder, the kind you buy in a pack of 20 from an office supply store. Inside it were documents, papers he had assembled himself, without a lawyer, because the lawyer he had hired 8 months ago had taken his retainer of $4,000, done nothing of substance, and then stopped returning his calls. Ezra had filed the complaint himself. He had typed it on his old computer, looked up the procedural requirements on the courthouse website, printed everything at the library on Cobb Street, and submitted it in person. The clerk at the filing window had looked at him over her reading glasses when he slid the papers across the counter, and her expression had contained a specific kind of pity that Ezra recognized, the pity of someone who has seen many people try to do what he was doing and knows how it usually ends. The case was a property dispute. Ezra had lived in his apartment on the 3rd floor of 44 Delancey Place for 22 years. He had paid his rent on time every month for 22 years. He had the receipts, all of them, kept in a shoebox under his bed in chronological order. 22 years of paper receipts going back to a time before digital records, before email confirmations, back to the days when a landlord gave you a handwritten slip and you kept it. 6 months ago, the building had been sold to a development company called Vertex Properties. Vertex had sent a notice informing all tenants that the building would be converted to luxury condominiums and that all current tenants were required to vacate within 90 days. Ezra had read the notice 3 times. Then he had looked up the law. What he had found, after 3 weeks of reading at the library and online and in the county law library where the public was permitted 1 afternoon a week, was that Vertex had not followed the required notice procedure for long-term tenants. Under the Residential Tenant Protection Act, a piece of legislation passed 11 years ago that most landlords and many lawyers had never fully internalized, tenants of more than 15 years who were current on rent were entitled to a minimum of 180 days notice, not 90, and were additionally entitled to a relocation assistance payment equivalent to 6 months' rent. Vertex had given him 90 days and no payment. Vertex had, in other words, broken the law. Specifically, Section 44B, subsection 3, paragraph 8 of an act that most people in the room today had never read and would never read and would never need to read. Ezra had read it 4 times. He had printed it out and kept it in the manila folder. The attorney representing Vertex Properties was named Gerald Marsh. He was 51 years old, a senior partner at Dunmore and Finch, a firm that had represented real estate developers in this city for 30 years. He was a large man, broad-shouldered, with the particular physical confidence of someone who has never had to wonder whether he belonged in a room. His suit cost more than Ezra's monthly rent. He had 2 associates with him, young men in identical dark suits who carried heavy briefcases and moved with the efficient deference of people whose job was to make their superior look even larger by contrast. Gerald Marsh had glanced at Ezra when Ezra sat down and had registered him and filed him in whatever internal category Gerald Marsh used for self-represented elderly tenants, and had returned to his phone. The judge was the Honorable Patricia Wren. She was 63, 20 years on the bench, efficient and unsentimental, and fair in the specific way of someone who had seen every variety of human foolishness and had long ago stopped being surprised by it. She did not look up when the case was called. She was reading the case file. Mensa versus Vertex Properties, the clerk called. Ezra stood. He walked to the front of the room, his folder under his arm, and took his place at the respondent's table. He set the folder on the table and placed his hands flat on either side of it, and he stood and waited. Gerald Marsh approached the plaintiff's table with his associates and set his briefcase down and opened it with the brisk confidence of a man performing a task he has performed so many times that it has become a kind of theater, familiar and comfortable and predictable. Judge Wren looked up. She looked at Gerald Marsh. She looked at Ezra. She looked back at Ezra for a moment longer than was strictly procedural, registering the old suit, the manila folder, the absence of any associate, any second chair, any briefcase. "Mr. Mensa," she said, "you are self-represented?" "I am, Your Honor," Ezra said. Something moved across the judge's face. Not quite the same pity as the filing clerk, something more complex, something that recognized what it was looking at and was not entirely comfortable with what it saw coming. "You understand that the court cannot provide you with legal advice?" "I understand, Your Honor." Gerald Marsh cleared his throat with the subtle satisfaction of a man who has already written the ending of a story in his head. "Very well," Judge Wren said. "Mr. Marsh, you may proceed." Gerald Marsh proceeded. He was good at his job, genuinely good, and he laid out Vertex's case with the smooth efficiency of long practice. The purchase of the building was legal. The development permits were in order. The notice had been properly served under the standard residential tenancy guidelines. He cited 2 cases, both familiar, both favorable. He was precise and unhurried, and he spoke with the authority of a man who knows the room is listening, because the room has always listened to men like him. When he finished, there was a brief silence. Judge Wren made a note. Then she looked at Ezra. "Mr. Mensa, you may respond." Ezra opened his folder. He did not rush. He found the page he was looking for. He knew exactly where it was, but he took his time, and he set it on the table in front of him. Then he looked up at Judge Wren. "Your Honor," he said. His voice was quiet and even, and carried perfectly in the stone room, with the natural projection of a man who had spent many years speaking in circumstances that required him to make himself heard without raising his voice. Counsel for Vertex has cited the standard residential tenancy guidelines. I would like to draw the court's attention to the Residential Tenant Protection Act of 2013, specifically Section 44B, subsection 3, paragraph 8. There was a pause. Gerald Marsh's expression did not change, exactly, but something in the region of his eyes became more attentive. Ezra continued. Under Section 44B, subsection 3, paragraph 8, a tenant who has maintained continuous and current occupancy of a residential unit for a period of 15 years or more is designated a protected long-term tenant. Protected long-term tenants are entitled, upon notice of conversion or development displacement, to a minimum notice period of 180 days, not 90, and to a relocation assistance payment equivalent to 6 months of their current monthly rent. Vertex Properties served me with a 90-day notice and has provided no relocation assistance payment. I have been a tenant of 44 Delancey Place for 22 years with no arrears. I am a protected long-term tenant under the Act. Vertex Properties is in violation of Section 44B, subsection 3, paragraph 8. He set the printed page on the table and looked at the judge. The room was very quiet. Gerald Marsh opened his mouth. He closed it. He turned to one of his associates and said something in a low voice, and the associate opened a laptop with quick fingers and began typing. Judge Wren was looking at something on her own desk now, pulling up what Ezra understood was the text of the act itself. The associate typed for 30 seconds. Then he leaned toward Gerald Marsh and said something. Gerald Marsh's jaw tightened. He looked at the judge. He looked at Ezra. He looked back at his associate. "Your Honor," Gerald Marsh said, "if I may request a brief recess to—" "Mr. Marsh," Judge Wren said. She did not look up from what she was reading. "Are you familiar with Section 44B of the Residential Tenant Protection Act?" A pause. Brief but visible, the way a very small crack in a very large wall is visible precisely because it is unexpected. "I am familiar with the Act in general, Your Honor. This specific subsection—" "Yes," Judge Wren said. She did look up now. "This specific subsection." Her voice was entirely neutral, which on a judge's face communicates more than any degree of visible emotion. She looked at Ezra. "Mr. Mensah, you have copies of the relevant documentation?" "I do, Your Honor." Ezra removed a set of papers from the folder, 3 copies neatly separated by paper clips, and carried them to the clerk, who distributed them with the practiced efficiency of someone doing a job they do correctly, because correctness is a form of respect for the work. What followed took 40 minutes. Judge Wren was thorough and unrushed. Gerald Marsh was forced, item by item, to acknowledge that his client had not followed the required procedure, that his client's legal team had not adequately researched the applicable statute, and that the notice served to Ezra Mensah was not in compliance with the law. The 2 associates sat at the table with the very still posture of people who are not moving because any movement might draw attention to them. Gerald Marsh, to his credit, did not attempt to argue the indefensible once it was clear the defense had failed. He was a professional, and he recognized the point of no return. Judge Wren ruled in Ezra's favor. She ordered Vertex Properties to provide a new notice of 180 days from the date of original service, meaning Ezra had gained an additional 3 months in his home. She ordered Vertex to pay the relocation assistance of 6 months' rent. She noted, for the record, that the Act's provisions were clear and that counsel for Vertex would be well advised to familiarize their practice with applicable tenant protection legislation before future proceedings. She looked at Ezra one more time before she closed the file. "Mr. Mensah," she said, "is there anything else you wish to address?" "No, Your Honor," Ezra said. "Thank you." She nodded. It was a small nod, economical, but it contained something, a specific quality of recognition, one professional to another, across the enormous distance that the courtroom had placed between them. She closed the file. The clerk called the next case. Ezra gathered his papers and put them back in the folder and tucked the folder under his arm and walked back down the aisle between the wooden benches. At the back of the room, near the doors, a young woman was sitting. She had arrived midway through the proceedings, a journalist for the local paper who had been assigned to cover a different case that morning and had stayed when she found she could not make herself leave. She had her notebook out and she was looking at Ezra as he passed, and he met her eyes briefly, and she said, quietly, almost involuntarily, "How did you know about that statute?" Ezra paused. He considered the question with the same unhurried attention he gave every question. "I read it," he said. "You read the whole act?" "I read everything relevant," Ezra said. "When the stakes are yours, you read carefully." He pushed the courthouse doors open and stepped out into the thin November light. The sky was still the color of old bone, and the air was cold and carried the smell of wood smoke from somewhere nearby. He stood on the courthouse steps for a moment and breathed it in. Down on the street, a man was selling chestnuts from a cart. The the smoke from the coals rising in a thin white column. A bus went past. A mother walked by with a child whose red coat was several sizes too large, the hem nearly at the child's ankles, the child walking with the peculiar wide-legged gait of someone whose coat has become an adventure rather than a garment. Ezra watched them and felt, very quietly, the specific satisfaction of a man who has done a hard thing correctly. Not triumph, not vindication, exactly, though there was a small warm current of that running underneath. Something older and simpler. The satisfaction of a craftsman who has made a precise cut and seen the two pieces fall apart along exactly the right line. He had 4 months left in his apartment under the new timeline. He would use them well. He would find somewhere else, and he would research the lease terms before he signed, and he would keep the receipts. Behind him, through the courthouse doors he had just come through, Gerald Marsh was on his phone. His voice was controlled but strained, explaining to someone on the other end of the call how a 67-year-old man with a manila folder and no legal training had walked into his courtroom and cited a subsection of a statute that a senior partner at a 30-year-old real estate law firm had failed to check. The explanation was not going well. The associates stood nearby, their briefcases at their feet, in the posture of people waiting for a storm to pass. Ezra walked down the courthouse steps and turned left on Meridian Street and put his collar up against the cold and walked at his own pace through the city that had never quite made room for him and that he had navigated anyway for 67 years, with the particular grace of a man who long ago made peace with the fact that the road is narrower for some than others and that this does not change your obligation to walk it well. The chestnut seller caught his eye as he passed and held up a small paper cone. Ezra reached into his coat pocket. He had exactly the right change because he had put it there that morning in anticipation, the way he anticipated everything. Not with anxiety, but with the steady forward attention of a man who respects the future enough to prepare for it. He paid. He took the chestnuts. They were warm in his hands in a way that the word warm does not fully capture. Not just temperature, but something like comfort, something like continuity, something like the small daily evidence that the world, for all its difficulty, contains moments of simple rightness that are available to anyone who has the patience and the presence to receive them. He walked on. The city moved around him. Somewhere behind him, in courtroom 7, the next case was being called, the next story beginning its slow negotiation with justice. And in the brief, warm weight of the chestnuts in his hands, in the clean, cold air, in the quiet knowledge of a thing done right, Ezra Mensah was exactly, entirely, where he was. The young journalist, whose name was Sophia Reyes, and who had been working at the paper for 14 months, and who had spent most of those 14 months covering school board meetings and parking ordinances and the kinds of stories that do not surprise anyone, walked out of the courthouse a few minutes after Ezra and stood on the steps and looked down Meridian Street and found she was still looking for him, though he was already gone. She had her notebook open, but had written almost nothing in it. There was nothing she could write that captured what she had watched. You had to have been there. You had to have heard the specific quality of the silence when Gerald Marsh's associate bent close and whispered in his ear, the silence that fell over the polished room like a cloth laid over a surface, covering, muffling, changing the shape of everything beneath it. She had covered 3 courtroom cases before this. In all of them, the outcome had seemed predetermined in some fundamental way, not dishonest, not corrupt, but weighted, tilted by the long accumulated gravity of money and professional experience and the 1,000 small advantages that come from knowing the room before you enter it. She had not known until this morning that a room like that could be leveled by a printed page and a calm voice and a man who had simply, with great patience and no shortcuts, done his homework. She would write the story. She would write it carefully because it deserved care. She would describe the folder and the suit and the polished shoes and the way Ezra had removed his papers with the precise, unhurried movements of someone who is prepared for exactly this and is not afraid of what comes next. She would describe Gerald Marsh's jaw tightening. She would describe the judge's nod at the end, economical, precise, one professional acknowledging another across an enormous gulf. She would try to find the right words for what it felt like to watch, and she would probably not entirely succeed, because the right words for certain things do not exist in the language, only in the experience. But she would write it anyway, because that was what you did with things that deserved to be witnessed. You tried, even knowing the attempt was imperfect, because the attempt itself was a form of honor. She closed her notebook and walked down the steps and turned right, away from the chestnut cellar, and the city received her back into itself the way cities receive everyone, without ceremony, without comment, without memory. In the apartment on the third floor of 44 Delancey Place, in the late afternoon of that same Tuesday, Ezra sat at his small kitchen table and made himself a cup of tea. The apartment was modest and old and perfectly ordered, not in the sterile way of spaces that have been arranged for display, but in the lived-in way of a space that has been cared for by someone who believes that caring for your surroundings is a form of respect for your own life. The shelves were full of books, their spines facing out, the titles visible: history, philosophy, law, poetry, natural science, the kind of reading life of a man who has never stopped being curious and has never needed a degree to be educated. There was a photograph on the windowsill, a woman, middle-aged, laughing at something outside the frame of the picture, her eyes bright. Ezra's wife, Miriam, who had died of cancer 9 years ago, and whose absence was the permanent weather of his life, not the sharp weather of grief, not anymore, but the deep background weather of a changed world, present in every room, in every cup of tea made for one, in the specific sound of an apartment that holds one person where it used to hold two. He sat with his tea and looked out the window. The sky was going dark now, the thin November light withdrawing early as it always did this time of year, and the city lights were coming on one by one in the windows of the buildings across the street. He could see, in the window directly opposite, a family at a table, a man, a woman, a child of perhaps 8, who was telling a story with large arm gestures that made the parents laugh. He could not hear them. He watched the laugh travel across the table, watched the child beam with the unself-conscious pleasure of someone who has made the people they love happy. And he felt the particular gentle ache of a man who has known such evenings and does not have them anymore, and does not begrudge their absence, because the having of them was real, and the memory of them is real, and neither of those things can be taken. He thought about the courtroom. He thought about the statute, section 44b, subsection 3, paragraph 8, which he had read many times now and knew with the intimacy you develop for things that have mattered to you. He thought about the moment when Gerald Marsh's associate had opened the laptop, the quick fingers on the keyboard, the pause, the lean, the whisper. He thought about what it was to know something precisely in a room that assumed you knew nothing. Not the dramatic pleasure of it, though there was a small thread of that, honest and human, but the deeper thing. The vindication not of his pride, but of his method. The confirmation that careful reading and patient thought and refusal to be hurried were not the habits of a foolish old man tilting at professional machinery, but tools, real tools, tools that cut. His father had been a tailor. His father had told him, more than once, in the unhurried way of men who say important things without ceremony, measure twice, cut once. He had applied this to cloth his whole working life, and he had passed it to his son without knowing he was passing it, the way the most important things are always passed, not through instruction, but through the accumulated example of a life lived with a particular kind of care. Ezra finished his tea. He rinsed the cup and set it in the drainer. He went to the shelf and took down a book, a history of constitutional law, one of 3 on property rights that he had borrowed from the county law library, and which he had been reading not because he needed them now, but because he had always believed, with the quiet conviction of someone who has built their understanding of the world page by page and fact by fact, that knowledge is not a tool you pick up when you need it and set down when you don't. It is a thing you carry. It is a thing you add to, continuously, the way water adds to a river, drop by drop, invisibly, until one day the river is deep enough to carry something large. He opened the book to where he had left off, adjusted the lamp, and began to read. Outside the window, the city made its ordinary night sounds: traffic, voices, the distant percussion of a world in motion. Inside, in the warm and ordered quiet of his apartment, Ezra Mensa turned a page, and then another, and then another. There are men who carry their whole lives in a single folder. This is not poverty. This is precision. And there is a great difference between the two. Though the world, which loves its categories and its quick assessments and its coats that cost more than rent, does not always take the time to learn it. Ezra Mensa had spent 67 years being the difference, quietly, without announcement, for anyone willing to pay the small and simple price of attention. Today, in courtroom 7, someone had paid it, the room had paid it, and the room, for one ordinary Tuesday morning in November, had been exactly as just as it was supposed to be.